Good morning. The hearing on the espionage case and the legal and constitutional issues raised by WikiLeaks before the Committee on Judiciary is now about to take place. We welcome everyone here to the hearing. In the Texas versus Johnson case in 1989, the Supreme Court set forth one of the fundamental principles of our democracy. That is, that if there is a bedrock principle underlying the First Amendment, it's that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. That was Justice William Brennan. Today, the committee will consider the WikiLeaks matter. The case is complicated, obviously. It involves possible questions of national security and no doubt important subjects of international relations and war and peace. But fundamentally, the Brennan observation should be instructive. As an initial matter, there's no doubt that WikiLeaks is in an unpopular position right now. Many feel their publication was offensive, but unpopularity is not a crime, and publishing offensive information isn't either. And the repeated calls from members of Congress, the government, journalists, and other experts crying out for criminal prosecutions or other extreme measures caused me some consternation. Indeed, when everyone in this town is joined together calling for someone's head, it's a pretty sure sign that we might want to slow down and take a closer look. And that's why it was so encouraging to hear the former Office of Legal Counsel, Jack Goldsmith, who served under George W. Bush, caution us only last week. And he said, "I find myself agreeing with those who think Assange is being unduly vilified. I certainly do not support or like his disclosure of secrets that harm U.S. national security or foreign policy interests. But as all the hand-wringing over the 1917 Espionage Act shows, it is not obvious what law he has violated. Our country was founded on the belief that speech is sacrosanct, and that the answer to bad speech is not censorship or prosecution, but more speech. And so whatever one thinks about this controversy, it's clear that prosecuting WikiLeaks would raise the most fundamental questions about freedom of speech, about who is a journalist, and about what the public can know about the actions of their own government. Indeed, while there's agreement that sometimes secrecy is necessary, the real problem today is not too little secrecy, but too much secrecy. Recall the Pentagon Papers case. Justice Potter Stewart put it, when everything is classified, nothing is classified. Rampant overclassification in the U.S. system means that thousands of soldiers, analysts, and intelligence officers need access to huge volumes of purportedly classified material. And that necessary access, in turn, makes it impossible to effectively protect truly vital secrets. One of our panelists here today put it perfectly in a recent appearance. He explained our problem with our security system and why Bradley Manning can get his hands on all these cables is we got low fences around a vast prairie because the government classifies just about everything. What we really need are high fences around a small graveyard of what's really sensitive. Furthermore, we're too quick to accept government claims that risk to national security, and far too quick to forget the enormous value of some national security leaks. As to the harm caused by these releases, most will agree with Defense Secretary Bob Gates. His assessment. Now, I've heard the impact of these releases on our foreign policy described as a meltdown, as a game changer, and so on. I think those descriptions are fairly significantly overwrought. And Mr. Gates continued, is this embarrassing? Yes. Is it awkward? Yes. Consequences for U.S. policy? I think fairly modest. So the harm here, according to our Republican Defense Secretary, is fairly modest. And on the other side of the ledger, there's no need to go all the way back to the Pentagon Papers to find examples of national security leaks that were critical to stopping government abuses and preserving a healthy democracy. They happen all the time. In 2005, the New York Times published critical information about widespread domestic surveillance. Ultimately, we learned of a governmental crisis that included threats of mass resignations at the Justice Department and outrageous efforts to coerce a sick attorney general into approving illegal spying over the objections of his deputy and legal counsel's office. If not for this leak, we'd have never learned what a civil libertarian John Ashcroft is. In 2004, the leak of a secret Office of Legal Counsel interrogation memos led to broader revelations of the CIA's brutal enhanced interrogation program at black sites. These memos had not been previously revealed to the Judiciary Committee or to many in Congress. Some feel this harmed national security, but to many Americans, the harm was a secret program of waterboarding and other abuses that might never have been ended but for the leak. And so we want to, as the one committee in the Congress that I have a great and high regard for, take a closer look at the issues and consider what, if any, changes in the law might be necessary. And I want to welcome this very distinguished panel. I've read late into the night, and I was awake most of the time when I was reading this, some really great testimony. And I'm so glad that you're all here with us. I'd like now to recognize my friend and ranking member, Judge Louis Gohmert.
Thank you, Chairman, and we do appreciate the witnesses here. Before I begin my actual statement, let me just say I appreciate and am also intrigued by your metaphorical use of the need for high fences around a small graveyard. But I'm curious, are you saying this administration is located in a small graveyard? Is that the point?
See me after the hearing,
Okay.
please, Judge Gomer.
Thank you, Chairman. And I appreciate the ranking member Smith asking me to stand in. But the release last month by WikiLeaks was of over 250,000 classified and diplomatic U.S. documents threatens our national security, our relations with foreign governments, and continued candor from embassy officials and foreign sources. Many have applauded the website and its founder, Julian Assange, as a hero, advocating that the continued release of classified and sensitive government documents, but to do so is both naive and dangerous. Websites such as WikiLeaks and the news publications who reprint these materials claim to promote increased government transparency. But the real motivation is self-promotion and increased circulation to a large extent. They claim to be in pursuit of uncovering government wrongdoing, but dismiss any criticism that their actions may be wrong or damaging to the country. As long as there have been governments, there have been information protected by those governments. There have clearly been documents classified that should not have been classified. While there is legitimate dispute over the extent to which information is protected and classified, it is simply unrealistic to think that the protection of information serves no legitimate purpose. Much attention has been given to this most recent WikiLeaks release. Many dismiss that any negative repercussions resulted from the leak, arguing that the documents, while embarrassing to the U.S., did no real harm to the country. But what about previous leaks by this website? On July 25, 2010, WikiLeaks released confidential military field reports on the war in Afghanistan. The site released Iraq war-related documents on October 23, 2010. Both of these leaks reveal sensitive military information that endangered American troops and may have bolstered our enemies' campaigns against us. Last month's WikiLeaks release has thrust into the spotlight an old, some would even say arcane statute, the Espionage Act of 1917. It has also resurrected an age-old debate on First Amendment protections afforded to media publications. But today we're confronted with a new kind of media, the internet blog. What are the boundaries of free speech? How do we balance this freedom with the government's need to protect some information? The drafters of the 1917 Act could not have foreseen that nearly 100 years later, sensitive government information could be transmitted to a global audience instantaneously. America's counterterrorism efforts must respond to new and emerging threats, such as homegrown terrorism. Our criminal laws must also keep pace with advancing technologies that enable widespread dissemination of protected information. This time the leak involved primarily diplomatic cables, but previous leaks disclosed even more sensitive information. And the next leak could be even more damaging. It could disclose the coordinates of where military personnel are located overseas, or even reveal the next unannounced visit to Iraq or Afghanistan by President Obama. This isn't simply about keeping government secrets secret. This is about the safety of American personnel overseas at all levels, from the foot soldier to the commander-in-chief. With that, Mr. Chairman, I yield back.
Thank you, Judge Gomer. This may be the last time that we have an opportunity to recognize our good friend Bill Delahunt of Massachusetts. He's served the committee in a very important way, and we yield to him at this time.
Well, thank you, Mr. Chairman. You know, as you're aware, I also serve on the Foreign Affairs Committee, and during that service, I had the opportunity to chair the Committee on Oversight. And I must say, and this is true of both the Bush and the Obama administrations. It was difficult for me in that capacity, and it was difficult for the chair of the full committee to secure information from the executive. I would submit that this particular hearing should be viewed in a much larger context. Leaks that obviously put people at risk, that put the United States at risk, and methods, et cetera, there has to be parameters. But I think we're at a moment in our history where there is a overwhelming overclassification of material. And I think that we, in our role as members of the first branch of government, ought to examine very, very carefully that the classification procedures. When you inquire of any executive agency and pose the very simple question, well, why is it classified? It's extremely difficult to get a direct and clear answer. Who does the classification? Is it the Secretary of State or the Attorney General? Who does the classification? During the course of my service, I discovered it was some low-level bureaucrat. And the process itself is arcane. And there is no accountability, I dare say, in the classification processes that exist within the executive branch. And that's very dangerous, because secrecy is the trademark of totalitarianism. To the contrary, transparency and openness is what democracy is about. So while there's a focus now on the issue of WikiLeaks, I think it provides an opportunity for this committee, and I think this is a concern that's shared by both Republicans and Democrats, about the classification process itself. There is far too much secrecy and overclassification within the executive branch, and I think it puts American democracy at risk. And with that, I yield back.
Thank you, Bill. I'm pleased now to turn to Howard Coble of North Carolina, senior member, who will soon be chair of at least one subcommittee, maybe two. We don't know yet.
Mr. Chairman, you're more optimistic than I am, but I appreciate that. I have no detailed statement. I want to associate your remarks regarding the gentleman from Massachusetts. He will be indeed be missed on this committee. This is a crucial issue, as known to all of us, and not unlike many crucial issues, and perhaps most crucial issues, it is laced very generously with complications. Good to have the panel with us, and Mr. Chairman, I yield back.
Judge, would you care to make an opening comment?
Mr. Chairman, I'm not going to have any opening comments regarding the testimony and such, just looking forward to it, but I do want just to say goodbye to Bill, obviously, of the Massachusetts delegation. He is the one member that I can clearly understand despite that accent of theirs. But truly, he's been a good friend, and again, just such a valuable member to the House, and he will be missed. But I'm hoping that, of course, he made the decision because he's moving on to something that's going to be even more rewarding than what he's done here in Congress. Again, thank you very much, Mr. Chairman, for the opportunity. I yield back.
Thank you, Judge Gonzalez. Judge Ted Poe I would recognize you at this time, sir.
Thank you, Mr. Chairman. I ditto what has been said about Bill Delahunt, a wonderful member of this committee. Hate to see him go, although we disagree probably on everything. A couple of comments about this situation. I see two issues. One issue is we got to find the original leak and what caused it, who did it, and hold them accountable. The other issues that this brings forth is the fact that after 9/11, the big talk was we need to share information with different agencies in the United States government because we don't know what one agency's doing or knows that should be shared. And so now we have mass sharing, and now we seem like we're going to move away from that because of this situation. I have no sympathy for the alleged thief in this situation. He's no better than a Texas pawn shop dealer that deals in stolen merchandise and sells it to the highest bidder. But he's doing it for political gain. He should be held accountable. But on the other hand, I'm very concerned about our own overclassification of information. The easiest way for a government agency to take information is to say, it's classified. Only special folks get to know what's in it. And I've been to a lot of classified briefings. And frankly, I've read a lot of that on the news, in the newspaper before that meeting ever took place. And it wasn't classified. Somebody just decides to make it classified, and then you have that whole problem of overclassification of documents. And lastly, the security of our information is important. And we have to, those who allowed this to occur by incompetence, negligence, or whatever, we have to fix that problem. I'm very concerned about that because of the fact that, you know, we're the greatest, powerfulest nation that ever existed, and we need to ratchet up our security to keep hackers from getting into it. And why did this occur? And who allowed it to occur? And what went wrong to make this situation now, you know, go worldwide? It's like a bunch of folks at a bank decide to hold a Christmas party down the street, and they all take off and leave the vault open. You know, there's a security problem with that kind of thing. And so I would hope that we would fix the security problem, find out what occurred and how it did occur. We ought to think through the idea of overclassification, and then thieves for political reasons or any other reasons, they also need to be held accountable. I yield back.
Thank you, Judge Pope. We welcome our witnesses, all 7. Ralph Nader, Professor Steve Vladeck, Mr. Gabriel Schoenfeld, Attorney Kenneth Wainstein, Thomas Blanton, Director of the National Security Archive, Attorney Abbe Lowell, well known to this committee and to previous Congresses, and our first witness, Professor Geoffrey Stone, Professor of Law and former Dean of the University of Chicago Law School. He's written quite a bit on constitutional law, several books, The First Amendment, Government Power. One of his books, Perilous Times, Free Speech in Wartime, was just recently praised by Justice Elena Kagan as a masterpiece of constitutional history that promises to redefine the national debate on civil liberties and free speech. We're honored by you being here, and we ask you to be our first witness, and all the statements of all of our witnesses will be introduced in their entirety into the record. Welcome.
Chairman Conyers, Judge Gohmert, members of the committee, thank you very much for inviting me and giving me this opportunity to speak with you about these issues. What I'd like to do is address the constitutionality of the proposed SHIELD Act, which has been introduced in both houses of Congress. The SHIELD Act would amend the Espionage Act of 1917 to make it a crime for any person knowingly and willfully to disseminate in any manner prejudicial to the safety or interest of the United States any classified information concerning human intelligence activities of the United States. Now, although this act might be constitutional as applied to government employees who unlawfully leak such material to persons who are unauthorized to receive it, it is plainly unconstitutional as applied to other individuals or organizations who might publish or otherwise disseminate the information after it has been leaked. With respect to such other speakers, the Act violates the First Amendment unless, at the very least, it is expressly limited to situations in which the dissemination of the specific information at issue poses a clear and imminent danger of grave harm to the nation. The clear and present danger standard in varying forms has been a central element of our First Amendment jurisprudence ever since Justice Oliver Wendell Holmes first enunciated it in his 1919 opinion in Schenck versus United States. In the 90 years since Schenck, the precise meaning of clear and present danger has evolved, but the principle that animates it was stated eloquently by Justice Louis Brandeis in his brilliant 1927 concurring opinion in Whitney versus California. Those who won our independence, wrote Brandeis, did not exalt order at the cost of liberty. They understood that only an emergency can justify repression. Such, he said, must be the rule if authority is to be reconciled with freedom. Such is the command of the Constitution. It is therefore always open to challenge a law abridging free speech by showing that there was no emergency justifying it. This principle is especially powerful in the context of government efforts to suppress speech concerning the activities of the government itself. For as James Madison observed, a popular government without popular information, or the means of acquiring it, is but a prologue to a farce or a tragedy, or perhaps both. As Madison warned, if citizens do not know what their own government is doing, then they are hardly in a position to question its judgments or to hold their elected representatives accountable. Government secrecy, although surely necessary at times, can also pose a direct threat to the very idea of self-governance. Nonetheless, the First Amendment does not compel government transparency. It leaves the government extraordinary autonomy to protect its own secrets. It does not accord anyone the right to have the government disclose information about its actions or policies, and it cedes to the government considerable authority to restrict the speech of its own employees. What it does not do, however, is to leave the government free to suppress the free speech of others when it has failed itself to keep its own secrets. At that point, the First Amendment kicks in with full force, and as Brandeis explained, only an emergency can then justify suppression. We might think of this like the attorney-client privilege. The client is free to keep matters secrets by disclosing them to no one. He's also free to disclose certain matters to his attorney, who is under a legal obligation to respect the confidentiality of her client's disclosures. In this sense, the attorney is sort of like the government employee. If the attorney violates the privilege by revealing the client's confidence, say, to a reporter, then the attorney can be punished for doing so. But the newspaper cannot be constitutionally punished for disseminating the information. Now, some may wonder whether it makes sense to give the government so little authority to punish the dissemination of unlawfully leaked information. But there are sound reasons for insisting on a showing of clear and present danger before the government can punish speech in this context. First, the mere fact that the dissemination of such information might, in the words of the proposed act, in any manner prejudice the interest of the United States does not mean that the harm outweighs the benefit of publication, as Chairman Conyers noted. In many circumstances, such information may indeed be extremely valuable to public understanding. Second, a case-by-case balancing of harm against benefit would be unwieldy, unpredictable, and impracticable. Clear rules are essential in the realm of free speech, and indeed that's one reason why we grant the government so much authority to restrict the speech of its own employees, rather than insisting that in every case the government demonstrate that the harm outweighs the benefit. Third, as we've learned from our own history, there are great pressures that lead both government officials and even the public to overstate the potential harm of publication in times of national anxiety. A strict, clear, and present danger standard serves as a barrier to protect us against that danger. And finally, a central principle of the First Amendment is that the suppression of public speech must be the government's last rather than its first resort in addressing a potential problem. If there are other means by which government can prevent or reduce the danger, it must exhaust those other means before it can even entertain the prospect of suppressing the freedom of speech. In the secrecy situation, the most obvious and the correct way for government to prevent the danger is by ensuring that information that must be kept secret is kept secret and is not leaked in the first place. Indeed, the Supreme Court made this very point less than a decade ago in a case known as Bartnicki versus Vopper, in which it held that when an individual receives information from a source who has obtained it unlawfully, that individual may not be punished for publicly disseminating the information absent the need of the highest order. The court explained that if the sanctions that presently attach to the underlying criminal act do not provide sufficient deterrence, then perhaps those sanctions should be made more severe. But it would be, the court said, quite remarkable to hold that an individual can constitutionally be punished merely for disseminating information because the government itself failed to deter conduct by a non-law-abiding party. This may seem a disorderly situation, but the court has in fact come up with a good solution. If we grant the government too much power to punish those who disseminate information, then we risk too great a sacrifice of public deliberation. If we grant the government too little power to control confidentiality at the source, then we risk too great a sacrifice of secrecy. The solution is thus to reconcile the irreconcilable values of secrecy on the one hand and accountability on the other by guaranteeing both a strong authority of the government to prohibit leaks and an expansive right of others to disseminate information to the public. The bottom line, then, is this: the proposed SHIELD Act is unconstitutional. At the very least, it must limit its prohibition to those circumstances in which the individual who publicly disseminates classified information knew that the dissemination would create a clear and imminent danger of grave harm to our nation or our people. Thank you.
Thank you very much, Professor. Our next witness is well known here, Abbe Lowell, Esquire, partner at McDermott, Will, and Emery. As a matter of fact, he served as chief counsel during the President Bill Clinton impeachment. He's also a former special assistant to the Attorney General and is well known for his criminal defense work, particularly in Espionage Act matters, including the 2007 APAC case. We welcome you back here again, Abbe. You may proceed.
Thank you, Mr. Chairman, and Judge Gohmert. It's always an honor to be in this particular room. Appreciate you receiving my statement. Let me say that the perspective I bring, as the chairman said, comes from basically 3 points of reference. The first is my service in the Justice Department for the Attorney General when issues of classification were being discussed. The second is 4.5 years of litigating under the Espionage Act in the so-called APAC lobbyists case that ended 30 days before trial when the Justice Department dropped it, and now representing a former Department of State employee also charged under the Espionage Act. These oversight hearings could not be more important or more timely to look at this principal law that's used whenever cases like the APAC lobbyist case and now the WikiLeaks case make the news. However, this law, as everyone has said, is about 100 years old, and it had flaws in it in terms of its language from the moment it was passed. And it is certainly shown to be outdated, at least ever since the debate that occurred in the Pentagon Papers case in 1971. However, as the chair has said, for all those commentators who are demanding that Congress do something here and now, this committee knows better that headline news is not the time to pass a new criminal law, especially when there are important constitutional principles at stake, because that inevitably leads to decades of unintended consequences and litigation. So what this committee is doing to begin the process of carefully considering these complicated issues is precisely the way to go, and it is the speed in which to travel. Let me start by issuing what I think are the four corners of the discussion. The first is that everyone agrees that there's a need for a strong criminal law to address real spying and espionage, to address in the intentional disclosure of what could be called classified national defense information with the intent to injure the United States or to assist an adversary. There needs to be a law prohibiting the mishandling of properly classified information. And against those three important national security principles needs the balance of protecting important constitutional rights. The problem is that the current law lumps all that I've said together, and the sections of the current law apply equally and have been applied equally when they are being used to go after a former FBI agent spy, Robert Hanssen, in disguise in secrecy in drop zones, or two foreign policy analysts having a spaghetti lunch across the river near the Pentagon. And any law that can apply to those two circumstances is a law that needs to be carefully scrutinized. One more introductory remark, if I may, and this has already been said by everybody across the way from me. When Congress starts deciding how to criminalize the disclosure of classified information, it should take into consideration how much overclassification there really is. We have seen in the WikiLeaks events material that bear a classification stamp that simply recounts what some diplomat believes is the private life preferences of a foreign leader, as opposed to when we are worried about what that foreign leader might do in a military action when properly or improperly provoked. Yet they both bear the same classification stamp. The problems of the law are many. The current law, the Espionage Act particularly, is so vague and so broad because it deals with words that don't have obvious meanings, such as information relating to the national defense, so that they can be applied immediately to a government employee who signs a confidentiality agreement. And then it can be applied to the foreign policy analyst who meets with that government employee and discusses what the government employee knew. And then it can be applied to a reporter who is overhearing the conversation between the government employee and the analyst and prints a story. Not only that, the current laws can be applied to each of these individuals, whether or not there's an actual document involved or whether the subject of the leak is an oral conversation. And not only that, a prosecution can be brought without the requirement of any of the disclosures involving an actual intent to injure the United States or to assist an adversary. And all this is made more complicated when there are good motives involved, such as somebody trying to bring to the attention of the public a lie the government has stated or a corrupt contract, or when the press is doing its job, or when lobbyists are doing theirs. Because, as the cases state, the First Amendment applies to the exchange of speech and ideas in our free society, whether the information is general foreign policy material or whether it happens to be classified. So the issue is the balancing of the very real and important national security interests of the United States in ever dangerous times. Over the past few decades, courts have grappled how best to apply the words of the law to these situations. In the AIPAC lobbying case, for example, the court made clear that to sustain a case under the Espionage Act, the government would have to prove beyond reasonable doubt that the defendants had a specific criminal intent to injure the United States and that they acted in bad faith. Now that there's the public disclosure of WikiLeaks and Julian Assange with thousands of documents, these same questions arise again. Does the law apply extraterritorially? Is he or is he not a journalist? Is there the ability to show an intent to injure? All of those are the beginning and not the end. So while the courts are straitjacketed, this committee and Congress is not. It can operate on a clean slate. And as I've indicated in my statement, let me give you what I think are 5 principles that any new law should consider. First, we must define spying differently from leaking. Second, we need to define what classified information, the release of which can ever be subject to criminal prosecution. Third, we must distinguish between disclosures of classified information done with an intent to injure the United States and those where a person is not acting with that criminal intent. Fourth, we must allow for some defense when information is improperly classified or when that information is so out in the public to base a criminal prosecution on it defies the notions of fairness and due process. And last, we need a law that will rationalize how it is possible to apply it to government officials and non-government officials, especially when those non-government officials are protected by the First Amendment. That is easier said than done. This is the beginning, I know, of a long process. I know it is possible to balance those two interests, and along with my panel members, I stand ready to help in any way I can.
Thank you, Abbe. Lowell. Our next witness, Kenneth Wainstein, is well known to the committee as well. He testified here last year, and he also testified as the Assistant Attorney General on National Security. So we welcome him back. He's a partner at O'Melveny and Myers, and he has a particular point of view that the committee feels is very important that we hear at this time. Pull the mic up closer, please.
Oh, I just missed the on button. There you go. I want to thank you again, you, Judge Gohmert, members of the committee. It's an honor to appear before you today along with this panel of distinguished experts and to testify about the recent WikiLeaks releases. This situation reflects a fundamental tension in our democracy. On one hand, there's the importance of the free press and the need to think very long and very hard before taking any steps that may chill the media's reporting on the workings of government. On the other hand, there's the need to keep our national security operations confidential so that we can effectively defend our nation against the threats it faces. Stephen Vladeck and I testified about this very issue before the Senate Judiciary Committee just this May, and at that time, our concern revolved primarily around the possibility of a leak to a traditional news organization. Since May, however, we've all learned that there is a much more serious threat. The threat posed by an organization that's committed not to the traditional media function of reporting newsworthy information, but to the mass and indiscriminate disclosure of sensitive information. Thanks to WikiLeaks, the government now has two very important decisions to make. The first is whether to prosecute Assange and WikiLeaks. The second is whether to revise the laws, the Espionage Act, to strike a better and clearer balance between security and freedom of the press. In terms of prosecution, the stakes for the government are very high. If WikiLeaks and Assange end up facing no charges for their mass document releases, which are about as audacious as I've ever heard of, they will conclude that they're legally invulnerable. They'll redouble their efforts to match or exceed their recent exploits, and copycat operations will sprout up around the internet. I was encouraged to hear the Attorney General's remarks the other day, and I commend the Justice Department for apparently undertaking a careful but determined effort to look into mounting a prosecution. If this effort does in fact ripen into a criminal case against Assange and WikiLeaks, it will certainly raise a host of hotly litigated issues, the most heated of which will be a strong constitutional challenge under the First Amendment. The main issue here will be the following. If WikiLeaks can be charged with espionage for these releases, there is no legal and no logical reason why a similar prosecution could not lie against all the other mainstream news organizations, because those organizations at one time or another publish similarly sensitive materials. And if every news outlet in our country is in fear of prosecution, then what happens to freedom of the press? This surely is a serious concern. It's the reason why the government has never prosecuted a news organization for espionage, and it's the reason we all should pause and think through the implications before charging into a prosecution here. The key to overcoming this concern is to demonstrate that WikiLeaks warrants this exceptional treatment because it is fundamentally different from other and real media organizations. By showing, for instance, that while the media focuses on disseminating newsworthy information, WikiLeaks focuses first and foremost on simply obtaining and disclosing official secrets. While the media gathers news through investigative reporting, WikiLeaks uses encrypted internet drop boxes that are specifically designed to collect leaked information and circumvent the law. While the media typically publishes only those pieces of sensitive information that relate to a particular story, WikiLeaks indiscriminately releases huge troves of leaked materials. By clearly showing how WikiLeaks is fundamentally different, the government should be able to demonstrate that any prosecution here is the exception and is not the sign of a more aggressive prosecution effort against the press. The government's second decision here is whether to revise the Espionage Act. All agree that the statute is badly outdated, and it could use revision on a number of points, such as clarifying the level of intent required to prosecute a leak case, determining when the government does and does not need to show that the leak actually risks damage to our national security before proceeding with a case, dropping the term national defense information and providing a clearer definition of that information that is protected by the Espionage Act. A clarification of these issues would go a long way toward making the statute more directly relevant to the espionage threats of the 21st century. WikiLeaks presents a challenge for the executive branch, which now has to decide how to respond to these disclosures. But it also presents a serious challenge for Congress, which has to decide whether we need new statutory tools to deal with this new threat. I commend the committee for stepping up to this challenge. Given the fundamental importance of this issue to our civil liberties and to our national security, I'm confident that it'll be time well spent. I appreciate your including me in this important effort, and I stand ready to answer any questions you may have. Thank you, Mr. Chairman.
We appreciate you coming before us once again. I think most people on the committee are resigned to the fact that we have to look at the Espionage Act in the coming Congress. Question is, of course, what do we do and how much change or what? We'll be talking about that with you when we begin our question period. Welcome, Mr. Schoenfeld, Senior Fellow at Hudson Institute, well-known author of Necessary Secrets, National Security, the Media, and the Rule of Law. You've testified in Congress on the responsibilities of the press during wartime, and we welcome you to the Judiciary Committee this morning.
Members of the committee.
Afraid it's not on.
It's an honor, Mr. Chairman, Judge Gohmert, distinguished members of the committee, to appear here today before you to discuss this issue of such vital concern to our country. The recent massive disclosure by WikiLeaks of U.S. diplomatic documents has sparked the most intense discussion of governmental secrecy in our country since the Pentagon Papers were published by the New York Times in 1971. Leading officials of the Obama administration have decried the damage. Ranking Republicans and Democrats in Congress have called for the prosecution of Julian Assange under the Espionage Act. Whether or not the administration takes legal action against Mr. Assange, we should not lose sight of the broader context in which this episode has occurred. And I would like to note several of its significant features. First, we live in the most open society in the history of the world, thanks in part to an unfettered press and the First Amendment, and thanks in part to laws like the Freedom of Information Act and the Presidential Records Act. We as a country are extremely well informed about what our government does in our name. Second, even as we are a wide open society, we have too much secrecy. Numerous observers across the political spectrum concur, as we here on the panel seem to be concurring today, that there is a great deal of mis- and overclassification within our national security bureaucracies. Third, owing in part to mis- and overclassification, the leaking of secret information to the press has become part of the normal, informal process by which the American people are kept informed. A study by the Senate Intelligence Committee counted 147 disclosures of classified information that made their way into the nation's 8 leading newspapers in one 6-month period alone. None of these leaks resulted in legal proceedings. Fourth, many leaks are innocuous and or authorized. For example, Bob Woodward's recent book, Obama's Wars, is replete with code names and descriptions of classified programs. No one has pointed to any specific damage caused by this book, perhaps because the only damage done was to the integrity of the secrecy system itself. Fifth, some leaks are unauthorized and exceptionally damaging. In 2006, to take one example, the New York Times revealed details of a joint CIA Treasury program to monitor the movement of al-Qaeda funds via the Belgian financial clearinghouse known as SWIFT. The Times published the story against the strenuous objections of leading government officials from both parties. There is reason to believe that our ability to track the flow of al-Qaeda and Taliban funds was severely hampered by the publication of a story that provided few discernible benefits to the public, if any. So I have sketched here a structure riddled with contradictions. On the one hand, we're a wide open society. On the other hand, we have too much secrecy. On the one hand, we have authorized and innocuous leaks of government secrets. On the other hand, we have unauthorized and highly dangerous leaks. And this is a very unsatisfactory state of affairs, and we have begun to pay a high price for it. And there are 5 things we need to do, in my judgment, all of them interlinked. First, we need to devote more attention and resources to declassification and to combating overclassification. Fewer secrets and a more rational secrecy policy will help us to preserve truly necessary secrets. Second, we need to make sure that legitimate whistleblowers have viable avenues other than the media to which they can turn. Third, we need to reestablish deterrence and prosecute those in government who violate their confidentiality agreements and pass secrets to the press or to an outfit like WikiLeaks. The Obama administration has been doing this with unprecedented energy. The last 24 months have witnessed 4 prosecutions of leakers, more than all previous presidencies combined. Fourth, we need, at the very least, to bring down the weight of public opprobrium on those in the media who disseminate vital secrets. And this body, the House of Representatives, contributed to that effort in 2006 when it passed a resolution reprimanding the New York Times and other news organizations for revealing the SWIFT monitoring program. And finally, we sometimes need to take legal action. We have never had a prosecution of a media outlet in our history, although we came close during World War II when the Chicago Tribune revealed that we had broken Japanese naval codes. While I believe that the First Amendment would not protect a news outlet that endangered the nation as the Chicago Tribune did in 1942, reasons of prudence suggest that such a prosecution should be a last resort, used against the media outlet only in the face of reckless disregard for the public safety. WikiLeaks, whether it is or is not a news organization, has certainly exhibited such reckless disregard. Thanks in part to the march of technology, it has been able to launch what might be called LMDs, leaks of mass disclosure, leaks so massive in volume and so indiscriminate in what they convey that it becomes very difficult to assess the overall harm, precisely because there are so many different ways in which that harm is occurring. The purpose of these leaks is to cripple our government, which Mr. Assange believes is a, quote, authoritarian conspiracy, close quote. But the United States is not such a conspiracy. It is a democracy. And as a democracy, it has every right to create its own laws concerning secrecy and to see to it that those laws are respected. And as a democracy, it has every right to protect itself against those who would do it harm. Thank you very much for your attention.
Thank you so much, Mr. Gabriel Schoenfeld. Our next witness, Professor Steve Vladeck, is professor of law at American University. He was part of the legal team that successfully won Hamdan versus Rumsfeld, challenging former President George W. Bush's use of military tribunals. He is well known to the judiciary, and as the WikiLeaks controversy has unfolded, he's further distinguished himself as one of the foremost national experts on the matter. We welcome you here.
Thank you, Mr. Chairman. Chairman Conyers, Judge Gohmert, distinguished members of the committee, thank you very much for inviting me to participate in this important hearing. I hope my testimony won't sound too much like a broken record. Testifying before the House Permanent Select Committee on Intelligence in 1979, Tony Lapham, who was then the general counsel of the CIA, described the uncertainty surrounding the scope of the Espionage Act as, quote, the worst of both worlds, unquote. As he explained, on the one hand, the laws stand idle and are not enforced, at least in part because their meaning is so obscure. And on the other hand, it is likely that the very obscurity of these laws serves to deter perfectly legitimate expression and debate by persons who must be as unsure of their liabilities as I am unsure of their obligations. Whatever one's views of WikiLeaks as an organization, of Julian Assange as an individual, or of public disclosures of classified information more generally, recent events have driven home Lapham's central critique that the uncertainty surrounding this statute benefits no one and leaves many questions unanswered about who may be held liable and under what circumstances for what types of conduct. In my testimony today, I'd like to briefly identify 5 distinct ways in which the Espionage Act as currently written creates problematic uncertainty and then, time permitting, suggest potential means of redressing these defects. First, as its title suggests, and as Mr. Lowell testified, the Espionage Act of 1917 was designed and intended to deal with classic acts of espionage, which Black's Law Dictionary defines as, quote, the practice of using spies to collect information about what another government or company is doing or plans to do, end quote. As such, the plain text of the Act fails to require a specific intent, either to harm the national security of the United States or benefit a foreign power. Instead, the Act requires only that the defendant know or have reason to believe that the wrongfully obtained or disclosed national defense information is to be used to the injury of the United States or to the advantage of any foreign power. No separate statute, as this committee knows, deals with the specific and, in my view, distinct offense of disclosing national defense information in non-espionage cases. Thus, the government has traditionally been forced to shoehorn into the Espionage Act 3 distinct classes of cases that raise 3 distinct sets of issues: classic espionage, leaking, and the retention or redistribution of national defense information by private citizens. Again, whatever one's view of the merits, I very much doubt that the Congress that drafted the Espionage Act in the midst of the First World War meant for it to cover each of these categories, let alone cover them equally. Second, the Espionage Act does not focus solely on the initial party who wrongfully discloses national defense information, but applies in its terms to anyone who knowingly disseminates, distributes, or even retains national defense information without immediately returning the material to the government officer authorized to possess it. In other words, the text of the Act draws no distinction between the leaker, the recipient of the leak, or the 100th person to redistribute, retransmit, or even retain the national defense information that by that point is already in the public domain. So long as the putative defendant knows or has reason to believe that their conduct is unlawful, they are violating the Act's plain language regardless of their specific intent, and notwithstanding the very real fact that by that point, the proverbial cat is long since out of the bag. Third, and related, courts struggling with these first 2 defects have reached a series of disparate conclusions as to the requisite mens rea that individuals must have to violate the Act. Thus, and largely to obviate the First Amendment concerns, Judge Ellis in the APAC case that Mr. Lowell testified about read into the Espionage Act a second mens rea. As he explained, whereas the statute's willfulness requirement obligates the government to prove that defendants know that disclosing classified documents could threaten national security and that it's illegal, it leaves open the possibility that defendants could be convicted for these acts despite some salutary motive. By contrast, the reason to believe requirement that accompanies disclosures of information, as distinct from documents, requires the government to demonstrate the likelihood of the defendant's bad faith purpose to either harm the United States or to aid a foreign government. Whether or not one can meaningfully distinguish between the disclosure of documents and the disclosure of information in the digital age, it is clear at the very least that nothing in the text of the statute speaks to the defendant's bad faith, nor is there precedent for the proposition that willfulness, which the Espionage Act does require, is even remotely akin to bad faith. In other words, courts have basically stumbled around to try to mesh the First Amendment concerns with the very vague and sweeping language of the statute. Fourth, and briefly, the potentially sweeping nature of the Espionage Act as currently written may inadvertently interfere with federal whistleblower laws. For example, the Federal Whistleblower Protection Act protects the public disclosure of a violation of any law, rule, or regulation only if such disclosure is not specifically prohibited by law and if such information is not specifically required by executive order to be kept secret in the interest of national defense or the conduct of foreign affairs. Similar language appears in most other federal whistleblower statutes. I dare say that the government would be reluctant to prosecute an individual who complied with federal whistleblower laws, but I think that the statute could be amended to remove that from even the realm of possibility. And finally, I won't even talk about this in detail because it's already been mentioned by my colleagues, the problem of overclassification. Should there be a defense for improper classification, how do we actually attack the real elephant in the room when we're talking about the disclosure of things that perhaps should never have been kept secret in the first place? What then is to be done? Perhaps unsurprisingly, in light of my observations above and those of my colleagues, I'd recommend 3 distinct sets of changes to the Espionage Act. First, introduce a clear and precise specific intent requirement that constrains the scope of the Espionage Act to cases where the defendant specifically intends the disclosure to harm national security and or to benefit a foreign power. I think you've already heard this one from Mr. Lowell. Second, create a separate lesser offense for unauthorized disclosures and retention of classified information, and specifically provide either that such a prohibition does or does not cover the public redistribution of such information, including by the press. If this committee and this body does decide to include press publication, my own view is that the First Amendment requires the availability of any number of affirmative defenses, that the disclosure was in good faith, that the information was improperly classified, that the information was already in the public domain, and or that the public good resulting from the disclosure outweighs the potential harm to national security. Third and finally, include in both the Espionage Act and any new unauthorized disclosure statute an express exemption for any disclosure that is covered by an applicable federal whistleblower statute. Mr. Chairman, in summation, testifying or writing in a law review article about 40 years ago, Hal Edgar and Benno Schmidt, 2 Columbia Law School professors, wrote that we have lived since World War I in a state of benign indeterminacy about the rules of law governing defense secrets. If anything, such benign indeterminacy has only become more pronounced in the last 40 years, and if recent events are any indication, increasingly less benign. Thank you for the invitation to testify. I look forward to your questions.
Well, you've left us with some very large challenges, Professor Vladeck, and we appreciate it very much. Our next witness is the director of the National Security Archive at George Washington University, Professor Thomas Blanton. In the year 2000, the archive won the George Polk Award for, quote, piercing self-serving veils of government secrecy, guiding journalists in search of the truth and informing us all. He's also the founding editorial board member of freedominfo.org, a network of international freedom of information advocates. I read your prepared statement with great enthusiasm, and we're happy to have you here today.
Mr. Chairman, it's a great honor for me and Judge Gohmert, and also to be in the middle of this extraordinary high-level tutorial in the Espionage Act and the Constitution. I feel like a grad student again, and it's a joy, actually. I also wanted to thank you, Mr. Chairman, for resurrecting my graveyard quote, that we have low fences around vast prairies of government secrets where we really need tall fences around small graveyards of the real secrets. And that's a core point I want to come back to today. I really have 3 points. One of them is the government always overreacts to leaks, always. And all you have to do is say the phrase Watergate plumbers, and you know what I'm talking about. Back then, they were discussing firebombing the Brookings Institution on the chance there might still be a copy of the Pentagon Papers in there. Today, you're having debates on Fox News. Let's do some targeted assassination attempts on Julian Assange. Well, I got to say, G. Gordon Liddy would be right at home. And both is absurd. And the overreaction the government typically does is not to kill anybody or firebomb something, but to go right to the second major point I want to make today. They're going to classify more information. What I'm worried about most is the backlash. I mean, in my prepared statement, I've got multiple examples of all the estimates, and they range from 50% to 90% of what the problem of overclassification really amounts to. Governor Tom Kean, head of the 9/11 Commission, after looking at all the al-Qaeda intelligence that we gathered before 9/11, said, you know, 75% of what I saw that was classified should not have been. And the commission said we not only needed to do information sharing between the agencies, we had to do information sharing with the American people, because that's the only way we could really protect ourselves. What a great lesson that is. And the system is so overwhelmed with the secrets that we can no longer really protect the real ones, and we can't let out the ones that would actually keep us all safer. And I think it's a mistake to try to see this as a balancing test. It's not a balance between openness and security. The findings of the 9/11 Commission were that more openness would have made us more secure. That's what you do in an open society to keep yourself safe. You're not safer in the dark. You don't hide your vulnerabilities. You expose them and you fix them. That's how we proceed in America. The third point I just want to make about where we are today, we're in the middle of a syndrome that one senior government official I really respect, holds all the clearances, does the audits, pushes back against excessive secrecy. He called it Wikimania. We're in the middle of Wikimania. And it's going to lead to so much more heat than light. Targeted assassination is only the most extreme case. But look at all the other proposals we've got on the table on the front burners to try to push back, to punish WikiLeaks, to push back against speech. I think the problem here is we've got to look at each one of those proposals and say, is that really going to address the problem? Is it going to reduce government secrecy, or is it going to add to it? Is it going to make us more safe? Is it going to make us more free? And do that test. The Wikimania is really coming from a series of what in my statement I call wiki myths. There has not been a documents dump. Everybody uses that phrase. There hasn't been one. The less than 2,000 cables are on the public record today out of that big database. And the editors of Le Monde and The Guardian and New York Times say that WikiLeaks is consulting with them about what to publish, what to redact, and doing the dialogue with government officials in a pretty extraordinary, responsible way. It's a very different posture, I should say, than WikiLeaks had even 6 or 8 months ago. I think the criticism they've gotten from journalists like us and from the public about endangering people's lives in Afghanistan and elsewhere, believe it or not, I think they've actually heard it. There's no epidemic of leaks. In fact, all 4 of the big WikiLeaks publicity spats have come from a single person, as far as we know, Bradley Manning, young private. So how do you solve the Bradley Manning problem? Well, you could do a pretty simple thing. The Defense Department has already done it. And here's a rational security policy. Just like you got 2 people to launch nuclear missiles, you got 2 people to handle a communications manual that has codes in it, have 2 people before you can download something from a secure network. Pretty simple. That would have stopped Bradley Manning, right? Mormons send out 2 people as missionaries because that's how you have accountability, right? You don't have solos. All right. There's no diplomatic meltdown from the WikiLeaks. I mean, there is a lot of heated rhetoric, but Secretary of Defense Robert Gates, who ought to know, he served every president in my lifetime, as far as I can tell. And Mr. Chairman, you quoted his remarks. Yeah, it's awkward. Yeah, it's embarrassing. But no, it's not a meltdown. It's going to make a job harder for diplomats. Maybe somebody's going to have to be reassigned. But, you know, in the long run, it's probably in the American national security interest for more foreign governments to be more accountable to their own citizens for their diplomacy. It's probably in our national security interest for the King of Saudi Arabia to actually be on the public record a little more often, and for Chinese Politburo members to get exposed every now and then. That might be a long-term goal of what American national security diplomacy ought to be about. And finally, there's not a set of wiki terrorists. I've heard that phrase batted around. They're not terrorists. I got to tell you, I wish every terrorist group in the world would write the U.S. ambassador in their local town, you know, days or a week before they're about to launch something, and ask the ambassador, hey, would you help us, you know, make sure nobody innocent gets hurt? Would you really work with us? We'd be glad to talk to you. Now, I understand why the ambassador didn't believe him, because WikiLeaks said, oh, and by the way, we'll keep anything you say to us confidential. It's kind of hard to square with the previous statements of WikiLeaks, but I wish every terrorist group would get into partnerships with Le Monde and El País and The Guardian and the New York Times to assess what the damage might be, to redact their own documents, to put regulators on the bombs they drop. That would be a good thing. WikiLeaks is not terrorists. And so that brings me my final real point and recommendation to this committee and to the prosecutors across the river in Alexandria, which is restraint. I know you don't usually have witnesses come up here and say, hey, let's all go take a nap. But, you know, in sleep-deprived Washington, we could use a little more restraint. I would say leave the Espionage Act back in mothballs, where it is right now and should stay. And in fact, what we know from some Freedom of Information requests, there's still some classified documents from 1917 that will give the Espionage Act very good company. Don't mess with it. Leave it alone. Our fundamental test should come out of Justice Stewart's dicta in the Pentagon Papers case and some wonderful articles that Jack Goldsmith has actually written in the last couple years, where he says, look, our problem is, you know, the fundamental cause of leaks is a sense of illegitimacy that's bred by excessive government secrecy. And how do you address that? You reduce the secrecy. How do you deal with the legitimacy problem? You make sure as few secrets as possible are actually held, and you protect those very strongly. So the test is, for all these proposals, legislative and otherwise, does it send a signal that will actually reduce government secrecy? Does it send a signal that we need maximum possible disclosure, in Stewart's phrase, to have a system that actually has credibility and can protect the real secrets and where we can protect ourselves? So I thank you, Mr. Chairman, for this opportunity to engage in this debate. I hope we'll reduce the mania a little bit and cut through some of the myths. Thank you, sir.
Thank you so much. Ralph Nader is well known, a leading advocate, an author, a lawyer, a presidential candidate. But Atlantic Monthly has named him one of the 100 most influential Americans in history. And I thought I would put that in the record so that more people that then read the Atlantic Monthly would know about it. We welcome you once again to the Judiciary Committee, Ralph Nader.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, and Congressman Gohmert, and the other members of the committee for this important and timely hearing. A lot of interesting, good points have just been made, and there's no point for redundancy. I'd like to mention that we ought to look at the issue of government secrecy and government openness with a historic cost-benefit evaluation. I worked with Congressman John Moss in 1966 on the first Freedom of Information Act, and I saw the fervent opposition of the bureaucrats in the executive branch to what was then a rather modest piece of legislation. I then worked with him on the strengthening 1974 Freedom of Information amendments, which made our Freedom of Information Act arguably the best in the world, and I also saw the same opposition. I think that people like Daniel Patrick Moynihan in his book on government secrecy point out that one of the first victims of government secrecy is the Congress itself. The Congress repeatedly has been repudiated from getting the information in order to perform its constitutional responsibilities, such as its war-making power, its oversight subpoena power, its appropriations, deliberations, and many others. Bruce Fein has decried this deprivation of information on the part of by the executive branch vis-a-vis Congress as a principal cause of weakening what is supposed to be the most powerful branch of our government. If you look at the historical record, the benefits of disclosure vastly outweigh the risks that come from disclosure. Wars could have been prevented if the American people knew what was going on in the Spanish-American War, in World War II, in the Tonkin Gulf Resolution, if the American people knew what was going on before the invasion of Iraq, with the lies, the cover-ups, the distortions that now have been historically documented by the Bush administration, including Richard Clark, the anti-terrorism counselor to President Bush, among many. What's fascinating about this WikiLeaks controversy is that we have to avoid it becoming a vast distraction, focusing on these so-called leaks instead of focusing on the abysmal lack of security safeguards by the executive branch of the U.S. government and making those who set up this porous system or who allowed it to be penetrated accountable. The distraction also is away from the lack of accountability for executive branch officials who suppress information. How many times have you seen those people prosecuted at the highest levels and the middle levels of government? The suppression of information has led to far more loss of life, jeopardization of American security, and all the other consequences that are now being attributed to WikiLeaks and Julian Assange. 1 million Iraqis have died as a result of the invasion, 5,000 U.S. soldiers, 100,000 sick and injured and traumatized, a country blown apart, more violent opponents to our country, more national insecurity. We have to be very careful here that the Congress does not stampede itself by executive branch pressure to repeat the Patriot Act debacle, when this committee issued a pretty sound piece of legislation with hearings, bipartisan, and then was stampeded along with the rest of the Congress by Karl Rove and George W. Bush with this notorious Patriot Act. Stampeded legislation always comes back to haunt its authors. Furthermore, I'm very disturbed by the reaction of Attorney General Holder. I think he's reacting to political pressure, and he's starting to fix the law to meet the enforcement policy. And that's very dangerous. He said the other day, quote, the national security of the United States has been put at risk. The lives of people who work for the American people have been put at risk. The American people themselves have been put at risk by these actions that are, I believe, arrogant, misguided, and ultimately not helpful in any way, end quote, referring to the WikiLeaks disclosures via the New York Times and the Guardian and other newspapers. Those very words could apply to the Bush administration and the Obama administration's military and foreign policy, that they would put us in greater risk. And it's very important for us, especially represented by Congress, that the penchant for secrecy is not nourished further by the WikiLeaks events, which are going to unfold in greater magnitude in the coming weeks, to leave millions of citizens in our country with a debilitating dictatorial vulnerability to further concentration of authoritarian power in the executive branch. Floyd Abrams, not known as a radical, arguably the leading First Amendment practitioner in the country, said, quote, in responding to Senator Lieberman's precipitous urging for Holder to indict Assange, he said, quote, I'd say the potential risks outweigh the benefits of prosecution. I think the instinct to prosecute is rational, and I don't mean to criticize the government for giving it serious consideration. But at the end of the day, I think it could do more harm to the national security, properly understood, than letting it go. Jefferson and Madison had it right. Information is the currency of democracy. Freedom of speech is inviolable. And I would add that secrecy is the cancer, the destroyer of democracy. We have overwhelming examples, some of which were in your statement, Mr. Chairman, of what happens when information paid for by the taxpayer, reflective of the public's right to know, is kept secret. If you take all of the present and probable future disclosures under the WikiLeaks initiative, the vast majority should never have been classified. The vast majority are reprehensible use of people employing taxpayer dollars. The vast majority should have been disclosed, if not never stated, for the benefit of the American people to hold their government accountable. Forbes magazine, in a cover story in its edition December 20th, outlines in an interview with Julian Assange that early next year, the beginning of the disclosure of corporate documents will start. Early next year, Forbes said, quote, A major American bank will suddenly find itself turned inside out. Tens of thousands of its internal documents will be exposed on WikiLeaks.org with no polite request for executives' response or other form warnings. Now, the importance of that is the danger of the following coalition appearing in the coming months. You have the government bureaucrats who transcend political parties, the government bureaucrats and the corporate executives who want to destroy the provision for whistleblower protection in the new Financial Reform Act as we speak, that they band together in order to focus on the WikiLeaks and try to stampede Congress and perhaps public opinion into enacting legislation that will further stifle the right of the American people to know and further enhance those who believe that the few can decide for the many and that concentrated power in the executive branch can make a mockery out of the constitutional authority reposited in the U.S. Congress. We hear a lot about the information age. We hear a lot about what it's supposed to do for us. But the risk in this WikiLeaks overreaction to control of the internet and to damaging a dissemination of compilation and access to information worldwide is very, very serious. That is only one of the consequences that can occur if the Congress allows itself to overreact and if the press does not take a measured view and hold to account those who are calling for executive assassinations, for repressions, for the detonation of due process against people who have received information from internal government sources. I think the proper range of government security is now being deliberated in the executive branch, but it needs to be stimulated by Congress. At DARPA, Peter Zatko and his group is busily working on a technical fix so that this kind of disclosure never happen again. Many people think that that cannot be done, that the genie of the internet is out of the bottle. But it does seem to me that we should be very careful in conclusion in not developing a bill of attainder mindset, if I may use that metaphor. If it's okay for Obama administration officials to conspire or collude with Bob Woodward, to use a non-normative intonation of those words, and leak cables and all kinds of secret information, and do it with impunity, with a reporter who then puts it in a book.
At some point, he needs to stop.
It does seem that we are on our way not for developing equal protection policy, but for the kind of discriminating policy that will make our legal system not reliable and subject to the distortions of repeated judicial decisions.
Mr. Chairman,
I'll leave you with that, Mr. Chairman. Thank you very much.
Well, okay, moot point.
Thank you, Ralph Nader. And my deep gratitude to all 7 of you. This may, in some ways, be one of the finest discussions the committee has had in the 111th Congress. I'm going to take my time, instead of directing specific questions, to ask all of you, or any of you, that now that you've heard each other, that you may have a reflection, or while you've been here in the hearing, you've thought of something you might like to add to your statement already, to have this opportunity to do so now.
Mr. Chairman, one thing I would like to respond to briefly is the point that my colleague to the left, Mr. Wainstein, made. I understand that we're grappling to try to figure out where the First Amendment applies and who is a journalist and who isn't. And I know many have said WikiLeaks and Assange are not because they, to use the phrase, dump data, or they don't perform the function of being selective. I think that's a dangerous slope to be standing on because it puts in the editorial room individual prosecutors who will make the decision as to who is a journalist and who isn't, and to individual courts all over the place as to what deserves First Amendment protection and what does not. And it doesn't distinguish well between what WikiLeaks has done and when a more traditional media outlet posts a document in toto on its website. So it makes for, I believe, a difficulty, and I think it's one that cannot be legislated. It has to be decided in another fashion. But I do want quickly to point out that it's easy to say. In American history, the function of gathering information from the government by whatever source and disseminating it to the public is classic journalism.
One thing that has happened is there was an alarm. The doors are all locked.
Yes, Mr. Wainstein.
If I may, thank you, Mr. Chairman. I appreciate Mr. Lowell's point, and that whenever you ask anybody, be it a court or a prosecutor, to try to distinguish between one person as a journalist and another person as a journalist, it's a dangerous slope to be on. Two responses to that. One is, we're on that slope right now. That's what the law allows as it stands, and Mr. Lowell made that point very well, that the current law allows the government to prosecute both the recipient of the information as well as the leaker of the information. The second point, though, is if you assume that there's ever going to be a case where a reporter or a person in the position of the news, the recipient of the information, can be charged, then that line has to be drawn. So go back to the Chicago Tribune case, which is the sort of the classic. 1942, the Tribune actually reports that we've broken the Japanese code. If the Japanese had paid attention to it, millions of lives, including many of our parents, might have been lost. They didn't, unfortunately, and they ended up not prosecuting the case. But I think many of us, or most of us, agree that is a case that's so egregious that that newspaper, that reporter should or could be charged. If you assume that there is such a case, then somewhere a line has to be drawn. And my point would be, is WikiLeaks, aside from whether you want to call them a newspaper or a news organization or not, is their mission and their mode of conduct sufficiently divergent from a traditional news organization, the type that the First Amendment was designed to protect, that it falls beyond that line, so that it could be prosecuted without the First Amendment standing in the way of its prosecution, and without other news organizations living in fear, other news organizations that pursue the traditional purpose of news and pursue the traditional modes of conduct of news gatherers and reporters, would then not live in fear that because WikiLeaks got prosecuted, they're going to be prosecuted, and therefore their actions wouldn't be chilled. That is the argument. So that, while I agree with Mr. Lowell that any definitional distinction is difficult and can be dangerous, it's where we are right now, and I think WikiLeaks, an argument can be made that WikiLeaks is exceptional enough a situation that a line can be drawn without such damage to the First Amendment.
Chairman, I would also compare this case to the Pentagon Papers case, where the Times spent a great deal of effort redacting the documents before it published them, which is not what is taking place here. This is a very different kind of enterprise. And of course, in that case, that was a prior restraint case, and the Supreme Court ruled that there was not, the standard had not been met for suppressing that information. It's also notable that 5 of the 9 justices said that if the case came to them after publication as a prosecution, they would strongly consider punishing the Times, prosecuting the Times, upholding a conviction of the Times for if the information was of the character that was prescribed. So I think that a prosecution of WikiLeaks, just judging by the very scant law we have here, the Pentagon Papers case, is a viable possibility.
Yes, Professor Stone.
Thank you, Chairman. On the discussion about whether WikiLeaks is part of the press or whatever, I think that's not a fruitless line of inquiry. I agree with Mr. Lowell that drawing a line along those directions is simply not going to be coherent. But I also, in terms of summary of things, want to come back to how clear it is from this discussion that the starting point is the classification system. That the bottom line is there cannot be any coherent solution to these issues without going back and examining the classification process and standards. And that unless we do refocus what's happened, because essentially over the last 70, 80, 90 years, we've run amok with secrecy. And that's created the problems that we've seen here. It's denied the Congress access to critical information, it's denied the courts access to critical information, and it's denied the American people access to critical information. And unless and until we go back and refix that, all of this is spinning wheels. I think that's really the place where this committee and where Congress has to start its inquiry.
Professor Blanton and then Ralph Nader.
Mr. Chairman, I just wanted to, at my own peril, try to correct Mr. Schoenfeld's analysis of what's going on here, because in fact a great deal of redaction is going on here on a daily basis, and we have extensive descriptions of it in the editor's notes by all the media outlets who are publishing stories on this matter, and that they have testified to the fact that WikiLeaks is following their lead after their reporters engage in exactly that discussion with the government about what the risk is, which is a discussion the Chicago Tribune did not have in its case and was its own, I think, journalistic failure, I would argue. So a great deal of redaction is taking place, and I would just point also to a certain trajectory. And I suspect that Mr. Assange's lawyers have maybe read some of Mr. Wainstein's testimony, maybe in advance of this hearing, because they're doing some very smart things to eliminate exactly the distinctions that you're trying to draw. They're asking the government for feedback on the documents. They are taking care to follow the lead of the media. They are actually doing the publication in concert with major media organizations who have the capacity that they do not have to do reporting. And in fact, they are looking more and more like a media organization. But I would even step back one from that, because my reading of the First Amendment as a layperson is that it also protects speech. And this goes to Professor Stone's point, not only freedom of the press, but speech. And it seems to me that you will run into really difficult problems, not only on the media slippery slope, but on speech. And it may go to motivation, may go to this fact of overclassification. I pointed out in my testimony in the written statement, but one of the most striking things about the wiki cables that are on the record is the fact that so many of the confidential and secret ones shouldn't have been classified to begin with. So you're going to be in a real mess, I think, in any kind of prosecution. But I'll leave it there.
Schoenfeld, you're entitled to a brief response.
Well, I found myself in agreement with many things that Mr. Blanton said in his statement, but one thing I strenuously disagreed with is the notion that WikiLeaks is responsible in what it's done. It may have indeed redacted some of the documents in the most recent disclosures, but we've had the two previous dumps of large numbers of documents, and I would say 2,000 cables that you refer to, in my judgment, is a large number of documents, and these were documents that were also about military operations, field reports, and a number of congressmen have referred to Secretary Gates's remarks dismissing the damage that was done by the latest disclosures. If one looks back at what his remarks were this past summer, he said that the lives of American soldiers and of Afghan civilians who cooperated with our efforts there were placed at risk. Chairman of the Joint Chiefs of Staff, Admiral Mullen, has said that there is blood on the hands of WikiLeaks. I think that these views are entitled to a great deal of respect. The notion that WikiLeaks is responsible seems to me unsupportable.
Ralph Nader.
I'd like to submit, Mr. Chairman, with your permission, for the record, an article, short article in the National Journal called Breaking the Ranks, Ron Paul Vigorously Defends WikiLeaks, where he asks his colleagues, which events caused more deaths, quote, lying us into war or the release of the WikiLeaks papers, end quote. I'd like to also introduce in the record Harvard Law professor Jack Goldsmith, who came out of the Bush administration, 7 thoughts on WikiLeaks, including the description of top Obama administration officials' cooperation with Bob Woodward, releasing top secret programs, code names, documents, meetings, and the like. I'd also like to include this full-page ad in the New York Times today by almost 100,000 Australians titled, "WikiLeaks Are Not Terrorists," and it's a rather sober and poignant appeal to Australia's ally, the United States, to cool it. I would also like to include in the record the full article in Forbes magazine on the forthcoming disclosures in the hundreds of thousands of documents of corporate crimes, corporate abuses, corporate cover-ups that Julian Assange has assured Forbes would be forthcoming. And just to reduce our ethnocentrism, Mr. Chairman, I'd like to note that WikiLeaks is not just a United States issue, that there are people in Peru, Kenya, Australia, Iceland, Switzerland, and other countries who have benefited from WikiLeaks disclosures of rampant corruption and injustice in those countries.
Without objection, your several documents will be accepted into the record. We have a record vote, and so we will take a brief recess and then resume the questioning of the members. Thank you for your patience.
Security in their hands, too. But I think they are, in effect, they're on training wheels, would be my argument. And if we can keep them there, I think that's a good thing. Well, no, I had this experience with Assange when he showed up in Berkeley. He showed up in Berkeley, California at this big investigative journalism workshop in April, expected to be greeted as conquering hero, and there was not a journalist in the room thought that. We all said, "You arrogant twit! What do you mean? You think you have the power to publish our tax forms, our medical records, anything you get your hands on? You don't. You got to have a code of ethics, and you don't have one." And that argument took place, and to me, that's a fascinating one because WikiLeaks now, by their actions, is trying to live up to certain standards that journalism community has arrived at about responsibility. To me, that's a positive development. That's a good thing. I think we, and so. I've already done. Oh, Mr. Chairman, real pleasure to be here.